in the statement that she gave police officers, she made a statement that you have a little bit of a trouble with your temper sometimes because that you get upset with a child. Mr. Willoughby, is the state ready to proceed? All right. You may call your first witness.
Mr. James, I think we've all read your report, but I just want to highlight some portions of it. When did you meet with him, to him being Mr. Jones?
I didn't actually meet in person with him. It was virtual. I did an interview with him.
Yes, ma'am.
It was July the 25th.
So a couple months ago. When you met with him virtually, the version of events that he gave you was obviously different than the report from the officer that you reviewed.
Yes.
And just to highlight this again, the victim was how old?
4 months.
Young little child.
Yes.
And if you remember, what kind of injuries did that child sustain?
I believe all 4 limbs were broken, fractured ribs, bleeding brain.
And as a result, did the child allegedly have seizures as well?
Yes.
Have what?
Seizures. Do you have any idea the status of that child right now?
No.
Moving our attention off of the 4-month-old Levi, what kind of criminal history did Mr. Jones have in his past?
From 2009, he had a reckless endangerment and a DUI.
And was that in Tennessee or another state?
That was in Kentucky.
And did, obviously he purports to have physical limitations. What were some of those that he told to you?
Well, he didn't elaborate on what he was diagnosed with. He just said that they had found some kind of spinal injuries, I think, compression, and that was making him fall.
Do you know if his injuries, and I don't know the answer to this either, but do you know if the injuries he purports to have today are related to that old criminal charge? Did he tell you how he got hurt?
No.
Okay. And other than that, what did you said he had a spinal injury. Did he elaborate at all about the lingering effects of that?
No.
Okay. I don't think I have any other questions, Your Honor.
Poland?
Follow-up questions. The state remarked about Levi, the 4-month-old child that was injured. Based upon your report, was it determined that the child had pre-existing injuries from being in the care and custody of someone else besides Mr. Jones?
Yes, it did say that some of the injuries were actually healed partially when they took custody.
So at the time of doing your report, we don't know exactly what injuries were sustained from Mr. Jones, is that correct?
Correct.
Moving forward, the only other charge that he has was something from approximately 15 years ago for a DUI offense, is that correct?
It's 2009.
2009. Also with that, I read in your report, do you recommend him for probation?
I do not recommend him. I think he could complete it successfully.
In your opinion, do you think he's better suited for probation or some type of alternative sentence compared to prison?
Probation or community corrections.
Thank you. Fair enough.
Mr. Willoughby?
Couple brief follow-ups. I just want to make sure I understood what you just said. You're not recommending anything,
No,
but you're saying he could complete either of those.
he could.
also could complete a prison sentence.
Yes, he can, yes.
Okay, so you're not giving an opinion,
No.
but all three of those options are on the table from creating your report.
He could get the treatment he needs from any of those places.
Yes, ma'am, thank you.
Anything further? Thank you, ma'am. You may step down. State has rested their proof. You wish to offer any proof, Mr. Poland?
Brent
All
Jones.
right, come up, please.
I do.
Brent, I'm going to ask you to state your full name for the record and spell your last name, please.
William Brent Jones, and it's Jones.
I'm going to ask you a series of questions, and I just want you to answer my questions, okay?
Yes, sir.
All right. You know why you're here today?
Yes, sir.
You're here for a sentencing hearing,
Yes, sir.
okay? And I want to ask you, how old are you?
60.
60 years old. And you heard the testimony from Ms. James. Have you ever been convicted of a crime after 2009?
No, sir.
Okay, other than what we're here for today?
Yes, sir.
Okay. Do you have any alcohol or drug problems or any dependency issues?
No, sir.
Tell us a little bit about your health issues.
Well, it's moved up to now to 7 compression fractures in my back. 2 of them are invading the spinal column, which causes nonstop pain, and I fall regularly because my right side will go numb.
Okay.
I didn't know this was happening then, but I do now.
Now, when you say the word then, when do you mean then, sir?
In 2021,
And you mentioned the word pain. Are you in pain today?
yes, sir.
Okay. And on a level of 1 to 10, what's your pain level today, sir?
A 7.
Now, are you scheduled for any surgery, sir?
Postponed a colonoscopy, the upper and lower barrels, and they're sending me to a cardiologist because I got an irregular heartbeat.
As far as your degenerative disc issues, are you scheduled for any surgery for that?
I'm not a candidate for surgery.
Why is that?
My bone structure is too porous and weak.
Okay. Are you 100% disabled?
Yes, sir.
Okay. Who is your doctor?
Dr. Natu was the neurosurgeon, and Mabel Alvarez, MD, is my primary care doctor.
How often do you see your primary care doctor?
Once a month.
Are you on a series of medications, sir?
Yes, sir.
How many would you say that you're on?
Over 25.
25 medications?
Yes, sir.
And how often do you take those?
Some of those are as needed, but I probably take 15 or 20 a day, every day, somewhere to the cycle of the day.
Mr. Jones, I'm going to hand you up a document. I'm going to ask you if you recognize this document, okay?
All right, sir. Very much, sir. I do recognize this.
What is that document, sir?
That is from the Med Center Health, which covers any doctor that's under that, and the list of all of my medication that I am taking and what the regimens are on those.
Okay, all right. Your Honor, I asked to move that as an exhibit.
Mark it as Exhibit 2. No, well, actually, the pre-sentence report was Exhibit 1. But I didn't hand it to you to mark it.
Not just yet. You also indicated that you are seeking a neurosurgeon, correct?
Yes.
Okay, I'm going to ask you to take a look at this document as well, sir.
Okay.
Could you please tell the court what that document is, sir?
It's calling out the pain, the source of the pain in the thoracic and the lumbar region, the numbness, people, weakness, numbness, lower extremities, multiple reason falls, presented to the med center after a fall. And he used a walker or a cane, and the significant fracture of T8, feeling the numbness and tingling extends down my back and the back of my leg.
Thank you, Mr. Jones. I move to make that Exhibit 3, Your Honor.
Exhibit 3.
You got me this. Next document I'm going to show, I'm going to ask if you recognize that. There's a doctor's name at the top of that. I think you alluded to that earlier. Is that-
I think that was actually the psychiatrist. I'm not 100% sure.
Could you please turn to the third page there, sir?
Okay. I see the notes in here, the percentage of loss in my vertebrae body height, and that's L1 and L4, and it's up to 15% vertical height, and then D5 is 15% of vertical height in the actual vertebrae itself.
Thank you. I move to make that Exhibit 4, please. Now, Mr. Jones, when did you start exhibiting these symptoms of back injury, spinal injury, sir?
About 4.5 years ago,
4.5
it was
years.
started out mild, and it was approached by the neurosurgeon conservatively. He said, let's see if we can try this, this, or this.
Okay.
And it's continued to get worse.
Silly question. I see that you're here with a cane and a back brace. All that has contributed, helps you get through your day-to-day life. Is that correct?
Yes, sir.
Okay. Has there been any indication that you'll be placed in a wheelchair at some point?
I'm actually ahead of the game because 2 years ago in July, my neurosurgeon said in a year he could expect me to be ambulatory.
Okay.
So that is coming.
Okay, all right. Now, if this court grants you an alternative sentence besides prison, such as community corrections or probation, do you think you could be successful in that, sir?
Yes, sir.
Okay. Do you think you'd be able to report, sir?
Yes, sir.
Do you think you would be able to remain drug and alcohol-free, sir?
Absolutely.
Do you think you'll be able to remain out of trouble, sir?
Yes, sir.
Part of the pre-sentencing report that you did with the young lady that just testified indicated that there was a suggestion that you do some anger management classes. Would you be willing to do those classes, sir?
Well, absolutely, sir.
And you would have no issues doing those classes?
No,
And you would have no issues doing whatever probation requested of you?
no, sir.
Now, Levi, was this an accident?
Yes, sir.
Terrible, unfortunate accident?
Yes, sir.
Do you feel bad about it?
Oh, yes. And I want to elaborate. After I got him calmed down that day and laid him over in his playpen, I had to go throw up. It was that bad. It scared me that bad.
Okay. Are you aware if he's made a full recovery?
Yes,
Are you asking this court today to place you on probation or some type of alternative sentence besides prison?
probation, part of it because of my health, and I constantly have to see my health care providers.
Thank you, Mr. Jones. I'll pass the witness, Judge.
Mr. Willoughby?
Mr. Jones, your spinal condition, you heard me ask Miss, just for the court reporter too, I didn't have her spell her name. the state's witnesses was Wendy James,
Yes.
WNDYJAMES. Forgot to do that. Back to you. You heard me ask her how you received your spinal injury. How did you receive it?
It's degenerative bone disease that's hereditary in my family.
But it wasn't a result of your DUI and wreck.
No, sir.
So it just happens.
Yes, sir.
And I understand that because my neck is screwed together too, so it hurts every day. Skipping past all that, back in 2021 in March, when this incident happened, were you in a similar physical situation,
Just starting, sir.
but you were still in pain?
Yes, but we did not have any idea how bad it was.
Who is we?
Me and of course, Tammy, that I was taking care of him. I did not know how bad it was until I got back to the doctor, and they did some more imaging and said, oh, we've got one that's a wedge, and we got another one that's, it's flat instead of being cupped for the disc to go in the vertebrae.
And you found out about that after March of
Yes,
2021?
yes, sir.
Had you noticed your legs going numb before that?
Off and on. It was nothing like it was sometime later.
So,
But
but you were having symptoms,
Yes,
not as severe as today,
yes.
but some. So when you guys came in the care of the child, did you not think that would be concerning and something that maybe,
It hadn't got to that point, sir, that I thought I needed to seek medical advice, because we were in the process, and you're talking about a child that's 2 months old. We're in the process to find a babysitter, and it was very difficult. And I thought I could handle him, and I couldn't.
let's talk about that too. When this happened, the version that you told police and the version that you told Ms. James are different. Would you agree with that?
Not sure, I haven't heard the two compared together.
Originally, you said you dropped him from a small bounce chair of some sort, and he fell and hit his head on part of that chair. Is that right?
I fell with him. is
That's not what you told police originally.
No, I know what I told him. I was there when Dunn and Diaz was there. I said, and I acted it out for him, sir, how I got him out, because there's three things wrong. He's hungry, he's dirty, or he's wet. So I went to get him out.
And when you did that, tell us the true version of what happened.
Well, when I
Act it out if you want to.
I'm not gonna try to get up. It's like the part of it, the changing table is here, and his little bouncy chair is over there. So when I get him up, and I felt, and he was wet, or damp. So I put him back in it, and I went to the kitchen to start his bottle, because I knew he was gonna be hungry. And when I went to pick him back up, I put his pacifier in his mouth, because he was showing signs he was hungry. And when I picked up and leaned on this right leg, he just completely gave out.
And then what happened?
I fell on him.
Whole body weight.
Still got the knots on my elbow to try to keep part of it from being full body weight.
But that's where he got hurt.
Yes, sir.
And then you called the police, right? Or an ambulance.
Not immediately, no, sir.
Did you call them at all?
No, not in the beginning. Because in just a few moments, he had calmed down. I fed him, and I didn't see anything visibly or physically that he had any distress. That didn't happen till the next day.
After your accident, you're calling it, did you immediately call Miss Petty?
Not that afternoon.
No, you didn't.
No.
So you understand how that could look like you were trying to just hide it and hope no one found out.
No, sir, I wasn't attempting to hide it when he,
I didn't say you were. I'm saying you can understand how that might look that way.
myself, I have to say no.
You don't understand how that would be.
No, I don't understand how that would be, sir.
With that, I understand. As a matter of fact, Miss Petty gets home, was the kid crying?
No,
Well, then at what point did his injuries become so visible or obvious that she calls and takes him to the hospital?
it was the next day before he started having any reactions.
And she took off work.
Yes, she'd already planned to take off work
When did you even tell her what had happened?
when she got home.
Okay.
And when I say when she got home, everything seemed to be all right, sir. I fed him, I changed him, I propped him up. The dog helped guard him when he's fussing, and he seemed fine, but it
But he-
deteriorated.
But he wasn't.
No, I know he wasn't now, but I did not know then.
And so he eventually goes to the hospital.
Yes,
But you didn't initiate that. She did.
well, we both did.
Both of
Say,
them.
yes, we discussed it, said, I don't know. Because he had that red place on the back of his head and said, we need to get him to the doctor.
Because he had a seizure.
Well, yes, that was later,
When did he have the seizure?
the next day,
And she probably took off work,
to take him to the doctor.
or maybe because she didn't trust you to watch him anymore.
No, it wasn't that.
Wasn't that?
No, sir.
Did, are y'all still dating?
Yes, sir.
Do you live with her still?
Yes, the address is in Pleasant View.
Is that where she lives?
Yes, sir.
Is that where this happened?
Yes, sir.
Have you even seen the child since?
No, sir.
When's the last time you saw him?
That next day after the fall, because I've not been permitted to have any contact with him, period.
Do you think that's probably a good idea?
Well, somebody other than me come up with that, but no, I don't think so, but I've made it very clear. If I don't have any contact with him, that's fine, as long as Tammy can.
Does she?
Yes.
Let's talk a little bit about, how did y'all even come into the care of him?
Well, his mother, they took him to an emergency room in North Carolina, and when they ran her history, she had an open warrant in Warren County, Kentucky. So they placed her into custody. We made a mad dash over and got Levi as she had requested,
From where?
the hospital in North Carolina.
Brought him back to Tennessee. Why wasn't the dad available?
He was deceased,
Why did he die? Or how?
fentanyl overdose.
Was that in Tennessee?
Oh, that was in Kentucky.
Kentucky. Now, is the mother currently in custody of this child?
I'm not sure. You know, the whole, I know that Stevie and Tammy communicate constantly about Levi.
Okay. So has Miss Petty had contact with the child since this?
Yes, I think she has. I mean, I can't be there if she actually does a video or FaceTime or whatever. I can't be present, so I can't say 100%.
And you honored that.
Absolutely.
And I know you say you're in a lot of pain today, but have you thought at all about what pain that child was in?
Yes, sir, I have.
And you don't really know if there's been lasting effects.
I'm not an MD, sir, so I can't say.
I mean, I know you're not a doctor. You read some doctor's words, but you also said the child made a full recovery.
Yes, he seemed to be fine.
How would you know that if you hadn't had contact with him? Or
That was
haven't?
on that day. Now, I don't have any
Okay.
contact. I have an order in
I know you do.
County that I can't have any contact with him.
I understand, but when your attorney was asking you questions, he asked you if the child had made a full recovery.
Yes,
My question is, if you have had no contact with this child and you're not a doctor, how would you know that?
I saw him on video.
Thought you said you honored the agreement not to be present.
I didn't initiate. She gets pictures from Stevie. She gets videos. And I told her I couldn't be a part of any of that FaceTime because of my stay away, basically. And I've been honoring that. And if he-
Except when you didn't.
Well, I saw him after the fact, sir. I'm not watching him live. Just
I
because I see
understand.
pictures of him, I see
Understand.
video.
I understand what you're saying, but you just said before that you had zero contact.
Well, I've not had any direct when you say from me.
You were pretty clear that you hadn't even seen him on video, and you removed yourself from those situations.
Well, I haven't since then after speaking to my counsel saying you don't need to watch those.
I understand.
There's
So-
pictures on the refrigerator. That's as far as I get, brother.
The pictures are different. That's
I
not what you.
understand.
It's just hard to believe that you would have had no contact and know the condition of this child.
I do through Tammy.
I understand. I don't have any other questions.
That last series of questions, you did not watch, you did not have contact with Levi in the present, in the live, is that correct?
No, sir.
It was an after-effect video that perhaps was shown to you saying, hey, look how good Levi's doing, is that correct?
Tammy has showed me videos. Yes, sir.
Nothing further, thank you, Judge.
I have a couple of questions for you, Mr. Jones.
Yes, sir.
How long had you been taking care of Levi, babysitting him or whatever?
Just a couple, 3 weeks, Your Honor. I'm not positive, but it was in
So
the
if
spring.
if the record says that your friend obtained custody of the child on March the 4th, roughly, would you have started taking care of him pretty quickly after that?
Yes, sir, sometime.
And you think it was 2 to 3 weeks?
She took off work for a while we were trying to find childcare for an infant.
And in the statement that she gave police officers, she made a statement that you have a little bit of a trouble with your temper sometimes because that you get upset with a child. I was trying to find her exact words. You remember her saying anything like that?
Not to
Said
me,
you
Your Honor.
get jealous, overzealous with a hush, hush, you got a hush kind of thing. Do you remember
No, sir.
anything? So you never had a problem like that?
No, sir.
So tell me exactly, one more time, how did this child get hurt?
He was in his, it was a playpen and baby bed all together, changing table. And he was fussing, so I knew he was wet, he was muddy, or he was hungry. When I gave him his pacifier in there, I went and started the bottle, and when I came back to pick him up, I had to spin to put him over to change him. And that's when the right leg gave out, and down we both went. And I actually fell on him.
So if is it Tammy, is that her name?
Yes, sir.
If Tammy told the police officers that you had told her that you had dropped him and his face or head hit the metal portion of the bed and that's what caused the lip injury, are you saying that she just was wrong about that?
Well, he had his pacifier in his mouth, Your Honor, and then try to go back and have direct recollection of that. I don't have full recollection because I was sicker than a dog because I had fell with him. And it was explicitly said that I fell with him and fell on him. I didn't try to cover up anything. She hadn't tried to cover up anything.
All right. Any questions based on my question? Step down. Mr. Poland, you have any other witnesses? Rebuttal proof? I'll hear you in argument.
Just starting with 4035, 114, I would believe that factor one could apply. It's not for range purposes, but he does have an admitted prior conviction for DUI and reckless endangerment out of Kentucky. I would also argue that factor four would apply. The victim was a 2 to 4 month old baby. I don't know how anyone in their life gets more vulnerable than that. So I would certainly think because of the age of the child, that factor would apply. I would also argue that number 5 applies. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the crime. All he had to do was seek help and tell the truth about what happened, and we probably wouldn't be here, or at least not here in this capacity today. I think even based on his testimony, he was trying to mitigate and hide what had happened. He did not seek attention. Ms. Petty, according to his testimony and her statement in the pre-sentence report, took off work the next day, and she was the one who initiated that. But for her, I don't know if this child would have ever been seen by a doctor. I'm glad it was, but it wasn't because of him. I've got 2 kids. Everybody in this room probably has kids. If I fell on top of a baby, the immediate thing I'm doing is seeking medical attention, no matter what. And he did not. So I would argue that number 5 would apply. I would argue number 6 would apply. The personal injuries inflicted or the amount of damaged property sustained was particularly great. Skull injuries, broken ribs, broken limbs, seizures. I would certainly think those would meet that factor for particularly great injuries. He says the child has made a full recovery. I mean, Your Honor has heard the testimony about how this kid came into their custody. Not the best start in life for a child, but, and the mother isn't here today for, I think, reasons the court can infer. And I don't know if the child's made a full recovery, but I do know the injuries sustained were not ungreat. And lastly, I would argue that factor 14 would apply. The defendant abused a position of public or private trust. Certainly private trust. The mother of the deceased father of this child trusted him every day while she went to work because he says he can't. And I know Your Honor has medical proof that would tend to back that up, but in any event, he was trusted with the care of this child. And I would argue that he failed horribly in that regard. So I would think 14 would apply. State's going to ask for 10 years to serve. I know he's got medical conditions, and we have Department of Corrections facilities that can handle those for him. I understand everything that he has said today. I think this is probably the closest to the truth that we'll ever get, but he's not been very consistent. He says he doesn't know and has honored the no contact. Then he says he knows the current condition, which I'm sure he does know through his friend, girlfriend, whatever they are. But then he says he saw a video. And, you know, he claims he told a consistent story from the beginning. And based on the pre-sentence report and his testimony today, that's just not true. He has not. He originally claimed he dropped this child 2 feet, roughly, from a bouncy chair, and he hit his head. And the whole reason we're here today is because the Vanderbilt Child Care Team said these injuries, based on that, are impossible. And now we know that they are, because he literally fell like a tree onto a child and did nothing about it. The only thing he's done about it to this point today, from anything I've read about this case, is try to mitigate it and excuse it. And there's no excuse for that, in my opinion. So that's what the state's asking the court to do.
Mr. Poland?
Your Honor, I think that we can all agree, all of us can agree that this young child, Levi, has had a horrible start to his life, and we can only hope that he has actually made a full recovery. Your Honor, after looking at the factors in 40, 35, 113 as mitigating factors, I point to number 8, the defendant was suffering from a mental or physical condition that perhaps significantly reduced the defendant's culpability for the offense. It does discuss voluntary intoxications, which is not applicable here, Your Honor. We have presented proof to this court that his beginning of his disability started on or about this time when he was in the care of the child. Your Honor, my client has exhibited symptoms today that have become full circle with his disability. We are arguing that he has an alternative sentence of probation or some type of alternative sentence other than prison. Your Honor, he is remorseful for these acts. He claims that these were accidents. strictly accidents. He has testified today, Mr. Jones has testified today, that the ambulance was called. The ambulance was called when he noticed there were injuries to the child, which was the next day with him and Miss Tammy Petty. Your Honor, there's not been any indication that he intended to hurt this child. His rendition of his stories may be cloudy based upon the situation at hand with the child being injured. Your Honor, I'm asking for my client to be sentenced appropriately to probation or an alternative sentence other than prison. Thank you, Judge.
Two things. As far as he didn't know his medical condition at the time. So he even said that. So I don't think that mitigating factor applies. But lastly, I'm just going to really disagree with the remorseful part. And Your Honor's recollection will have to trump mine, but I don't think he said, "I'm sorry," one time when he testified. He's remorseful about the consequences, and he wasn't remorseful enough about what had happened to seek medical attention. And today, all we've heard is a sob story, and I'm sure he is in pain. And I'm sure he does have back issues. Like I said, I broke my neck when I was 19. I got the same problems. But that has nothing to do with this child and the remorse for it. I don't think there has been any remorse. Just a lot of excuses, a lot of woe is me's, and not one time have we really focused on who got hurt. So I just disagree with that part.
All right, anytime that I'm required to impose a sentence at a sentencing hearing, I am required to follow the Tennessee legislature's instructions as set forth in our Tennessee Code. And those are set forth, the considerations for sentencing are set forth and encapsulated in the 4035-103 of the Tennessee Code. And that provides the following: to implement the purposes of this chapter, the following principles apply. 1, sentences involving confinement should be based on the following considerations. A, confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. I do not find that to be the case here. B, confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrence of others likely to commit similar offenses. And I think that that is the argument that the state can make, that it's a sentence of confinement is necessary to avoid depreciating the seriousness of this offense. C, measures less restrictive than confinement have frequently or recently been applied. That one would not apply. Second factor is the sentences imposed should be no greater than that deserved for the offense committed. Third, the inequalities of sentences that are unrelated to the purpose of this chapter should be avoided. 4, the sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. 5, the potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining a sentence alternative or length of sentence to be imposed. And trial judges are encouraged to use alternatives to incarceration that include requirements for reparation, victim compensation, community service, or all of these. Following that, the first thing that the court is required to do is to determine his range. He is a range 1 offender. He has just one prior conviction for DUI, so he's clearly a range 1 offender. Then I look to the sentence range, and that is a Class B felony that he pled to. He was charged with Class A felony aggravated child abuse. And as a part of the plea agreement, he pled to and admitted his guilt to attempted aggravated child abuse. That's a little different than a nolo contendere plea. Is no different. It's basically he has admitted that he is responsible for attempted aggravated child abuse. So when we look at the sentence range, it is a Class C felony Class B felony, which is 8 to 12 years for a range one offender. So that's the sentence range that I'm determining in this case. To determine what is the appropriate range, I look to the enhancement and mitigating factors. And since the state goes first, I will go ahead and deal with those factors that the state relies upon. Number one, the defendant has a previous history of criminal convictions or criminal behavior in addition to the necessary to establish the appropriate range. You know, he has a prior DUI conviction. I'm not sure that would establish a criminal history that would, but it is on his record, so he does have a criminal history. I don't attribute very much weight to that first factor for that reason. It is just an isolated case many years ago. The second factor that they rely upon is 4, the victim of the offense was particularly vulnerable because of age or physical and mental disability. I do find that to be a factor that is applicable in this case. 5, the defendant was treated or allowed a victim, the defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. Now, state argues that that's applicable. The defense argues this, and the defendant himself testifies that this is all just an accident. The evidence that has been presented to me in the form of a pre-sentence report, and again, I would simply remind you that he has pled guilty to a charge of attempted aggravated child abuse. In reading through the pre-sentence report, I will make certain statements here that is what was found out by the investigators who investigated this crime. I'm starting on page 5 of the pre-sentence report because I think it's instructive and important to know what the court is relying upon. Second full paragraph states, myself and investigator Makaba then met with a social worker and a doctor that had requested to meet with us prior to us meeting with the LP's guardian, LP being the minor child. We met with a social worker, Laura Chandler, and Dr. Heather Williams, who are a part of Vanderbilt's care team. Laura and Dr. Williams advised the following via audio recorded verbal statements. Dr. Williams advised that LP was transferred to Vanderbilt after initially having a CT scan done at a third-party hospital. The initial scan revealed that LP has a brain injury and a brain bleed, which is consistent with recent trauma to the head. This injury and bleed is also causing LP to have seizures now, which is what prompted EMS to be called to 1037 Heatherwood Road the night prior. Dr. Williams also stated that LP has broken bones in all limbs. Broken bones in all limbs. Several broken ribs that are in various stages of early healing. None of the healing stages had developed callus and therefore may have occurred within a 14-day range of time, per Dr. Williams. LP also has a torn upper lip frenulum, which is consistent with trauma to the mouth or severe forceful feeding. Dr. Williams stated that at the time of the interview, she is awaiting LP's MRI results, but that she stated, that's not going to change my level of concern. If anything, it'll probably add to it because we'll have more details. She added that Tammy had disclosed a reportedly accidental fall that LP had suffered on March 29, 2021, where William dropped LP, which caused him, LP, to strike his head against a metal leg of a bassinet swing. Reportedly, as a result of the fall, LP sustained an abrasion to his mouth. Dr. Williams stated that she would say that if the injury to the mouth was the only injury LP had reportedly had as a result of the fall, she would, quote, give them that, end quote. However, she maintained that the fall could not have occurred from high enough to explain any of the other previously described injuries, and that it certainly, and it, quote, certainly would not have caused these fractures. They're very specific for abuse. She continued to say that the rib fractures LP has are consistent with squeezing or big blunt trauma to the back or chest wall, and that the fractures that he has on his arms and legs are really specific for either forceful yanking or the flailing of arms and legs when a baby is shaken. Dr. Williams stated that she could not definitively say that all of the fractures were not present prior to Tammy and William gaining temporary custody of LP. However, the brain injury and mouth injury definitely occurred recently. She did state that probably most of the fractures weren't there prior to Tammy having custody of LP on March the 4th. Dr. Williams had knowledge of the date of her gaining custody of LP from her own interview of Tammy prior to meeting with us. I'm going to go through a little bit more. In the interview with Tammy, the interviewers stated that, as I asked Mr. Jones about, said that she had no problems with him taking care of the children, but that he would get frustrated. He gets overzealous with the hush, hush, you gotta hush kind of thing. So, in looking at the factors that could be applicable, the fact, and I agree with the state and Mr. Willoughby's argument that a child who, even if you accept what Mr. Jones says is true, and I will state for the record that I'm accepting what Dr. Williams, I think it was, said, that these injuries within the 14-day window of them seeing this child on March 31st, 14 days from that date, places this child under the care of Mr. Jones, who says by his own admission that he had provided care for this child day in and day out from 2 to 3 weeks. 2 to 3 weeks would be 14 to 21 days. That's within the window of what Dr. Heather Williams says these injuries occurred. And whether you accept his idea that he fell on this child and therefore caused this injury because to the ribs, you could say that might be the case. But the fact that those fractures to this child's arms and legs did not occur in that way. They were very specific for the type of abuse, for yanking, jerking, or shaken infant syndrome, which I have some familiarity with because of a case that I tried early in my legal career. As a result of that, I think that it is clear that this child was abused physically, and it occurred during the time frame that Mr. Jones has testified he was providing care for the child. And the fact that this child was injured and that Mr. Jones did not notify anyone of those injuries and did not seek medical attention, a grown man falling on a 4-month-old child, nothing else, you just want to eliminate the possibility that there was an injury to the child. And not seeking medical attention for this child caused this child to have brain seizures and brain bleeding that could have been potentially avoided by prompt medical care. As a result of that, I do find that the factor that he treated or allowed the victim to be treated with exceptional cruelty during the commission of the offense is applicable. Number 6, the personal injuries inflicted upon, amount of damage to the, again, the type of injuries this child had are horrendous. And as a result, I found that to be applicable as well. The final factor that the state relies upon is number 8. Number 6, which was that the personal injuries inflicted upon and the amount of damage sustained was particularly great. So I do find that the 4 factors cited by the state are all applicable, although I do not attribute much weight to factor number 1. Then looking at the mitigating factors. I'm sorry? Okay, 14, I'm sorry. I didn't write that one down. I must not have been paying attention. The defendant abused a position of public or private trust, or used a professional license in a manner that significantly facilitated the commission of the fulfillment of the offense. And that would, in my opinion, apply as well because of the simple fact that he was the caregiver for the child, and therefore his having committed the offenses of attempted aggravated child abuse while he was providing care for the child, that would clearly apply. So I have now found that 5 different factors, enhancement factors, are all applicable. Looking to the mitigation factors, the one mitigation factor that the defense argues is number 8, which is the defendant was suffering from a mental or physical condition which significantly reduced the defendant's culpability for the offense. However, the involuntary use of intoxicants does not fall. Well, the physical condition reducing the culpability of the offense does, if his physical condition was such that he fell, that does not, in this court's opinion, justify the finding that within 14 days of March 31st, 2021, that this child had fractures of both arms and legs that could not have been imposed, in my opinion, and by the medical proof, by a simple fall. And as a result of that, the fall that was the physical condition didn't contribute to or reduce his culpability as to the injuries this child had. So I found 8 factors in enhancement, no factors that really apply for mitigation. So the question then becomes to set the range of punishment. This court, having considered those factors, finds that the appropriate sentence in this case would be 10 years in the Tennessee Department of Corrections. I declined to grant him probation. I declined to grant him alternative sentencing. The reason that I declined to do so is because of the fact that this is a case that granting probation to someone who abused a child in such a manner would, in my opinion, have created such a depreciation for the severity of the offense. And unfortunately, child abuse is something that we see all too often in this court. You have something else, Mr. Willoughby? In any event, I do find that the sentence, I don't find that the community corrections is applicable in this case, nor do I find that alternative sentencing of split confinement and so forth. Mr. Jones's physical conditions can be addressed and treated in the Department of Corrections. They have medical care and facilities where special needs can be addressed. So therefore, it is the court's sentence that Mr. Jones be sentenced to 10 years in Tennessee Department of Corrections as a range 1 offender, and that sentence will be to serve. He is remanded to the Department of Corrections to begin serving his sentence. We will stand in recess for about 10 minutes.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.